Hello everyone. I am Dr. Anurag Tiwari, and today I am with the judgment of Rajanish KV versus K.Deepa and others, which is announced by the Honorable Supreme Court today. And I'm, I mean, certainly I'm going to say that it is going to be one of the most celebrated judgment of the Honorable Supreme Court for with reference to Article 233, Clause 2 of the Constitution. This judgment is decided by the Constitutional Bench, comprising of Chief Justice of India B.R. Gavai, Justice Arvind Kumar, Justice Satish Chandra, Justice K. Vinod Chandran, and Justice M.M. Sundares. And out of these five judges, Justice M.M. Sundares gave his separate judgment. He authored his own judgment, and the judgment on behalf of others were authored by the Chief Justice of India, B.R. Gavai. Now, under this judgment, the Honorable Supreme Court took a liberal approach while interpreting Article 233, Clause 2, that deals with the appointment of district judges. And while deciding this judgment, it referred 10 judgments, out of which 5 were overruled. And today, I'm going to discuss only the substantial questions of law framed by the Honorable Supreme Court while deciding this case and the corresponding answers to those questions. While the fact of the case starts with the, I mean, deciding of this case or hearing of this case with the three judge bench, who later on 12th August 2025 referred with two substantial questions for the constitutional bench for their decision on those two substantial questions. The first one is whether a judicial officer who has already completed 7 years in bar being recruited for subordinate judicial service would be entitled for appointment as additional district judge, that too against the bar vacancy. And the second question was whether the eligibility for appointment as a district judge is to be seen only at the time of the appointment or at the time of the application, or both. Now, when the five judge bench, I mean, assembled, it framed two additional questions in addition to those two questions referred by the three judge bench. The third question is whether there is any eligibility prescribed for a person already in the judicial service of the union or state under Article 233, Clause 2 of the Constitution of India for being appointed as district judge. And the fourth question is whether a person who has been civil judge for a period of 7 years or has been an advocate and a civil judge for a combined period of 7 years or more than 7 years would be eligible for appointment as district judge. Now, these questions were framed while interpreting Article 233 only. The reference was Article 233. Now, the constitutional bench concluded with the following answers for the above framed questions, in which the first of all it says that the judicial officers who are already completed 7 years in bar before they were recruited in the subordinate service would be entitled for being appointed as a district judge or additional district judge in the selection process for the post of district judge in the direct recruitment process. For second question, the court answered that the eligibility for appointment as a district judge, additional district judge, is to be seen at the time of application only. For third question, the answer is though there is no eligibility prescribed under Article 233, Clause 2 for a person already in judicial service of the union or of the state for being appointed as district judge, in order to provide a level playing field, we direct that a candidate applying as in service candidate should have 7 years combined experience as a judge, as a judicial officer, and an advocate. And fourth, it says that a person who has been or who is in official service and has a combined experience of 7 years or more as an advocate or a judicial officer would be eligible for being considered and appointment as a district judge or additional district judge under Article 233 of the Indian Constitution. And in addition to these four questions, court also said that in order to ensure level playing field, we further direct that the minimum age for being considered and appointed as a district judge or additional district judge for both advocates and judicial officers would be 35 years of age as on the date of application. And further, the court also said it is also held that the view taken in the judgments of this court, right from Satyanarayan Singh versus High Court of Judicature at Allahabad and others of 1985 till Dheeraj Moore versus High Court of Delhi 2018, which take a view contrary to what has been held here in above. It means the first four principles, and lay down the incorrect proposition of law. And along with this, the court also held that all such rules framed by the state governments in consultation with the high courts, which are not in accordance with the aforesaid answers, those answers which are given by the Supreme Court in this judgment, shall stand quashed and set aside. It is directed that all the state governments, in consultation with the high courts, shall either frame or amend the rules in accordance with what has been held by this court in this judgment. And the court also gave a period of 3 months to frame these rules from the date of judgment, that is 9th of October 2025. Along with this, the court also clarified that this judgment will be applicable from the date of judgment only, that is again 9th of October 2025, and will not affect any appointment made prior to this judgment. There is an exception also. What exception is for such cases where an interim order were passed by any of the honorable high courts or the Supreme Court. So this judgment has changed the whole scenario of Article 233 Clause 2. Now, this is the interpretation given by the Honorable Supreme Court, and it is going to prevail all over the country. As being the apex court of our country, it is the duty of Honorable Supreme Court to interpret the provisions of the Constitution, and it has rightly done so by the Honorable Supreme Court, by the, in fact, the constitutional bench of the Supreme Court, which is going to prevail over all other previous judgments of the Supreme Court. Thank you.